This is your time during the day to hear some legal news updates while you enjoy your lunch. And I've been talking about firearms law for the past couple of Scaringi law news minutes or legal minutes, and this will be the last time that we discuss firearms law for the foreseeable future. And the next episodes we'll branch out and talk about some other areas of the law that may be of interest to you that are generating some national news headlines. Well, the issue of 3D downloadable firearms has exploded onto the national news scene. Many Americans have learned for the first time that with advancements in computer technology, it's possible for anyone who has a computer and a 3D printer to make his own firearm. Last Tuesday, August 1st, was supposed to be the dawn of a new age. Cody Wilson, the man behind the development and the sharing of this new technology, had posted on his firm's website, "The age of the downloadable gun formally begins." Emboldened by his recent settlement with the United States Department of State, which permitted and licensed this new endeavor, Wilson promised to make his digital blueprints for the do-it-yourself construction of firearms available to the public by August 1st. However, gun control advocates sprung to action before he could do it, and they stopped him in his tracks, at least temporarily. Attorneys general from 8 states, including Pennsylvania, filed suit in the U.S. District Court for the Western District of Washington State. They filed suit against Wilson, his firm, Defense Distributed, and the United States Department of State. They requested an emergency nationwide temporary restraining order prohibiting Defense Distributed from making its digital blueprints available to the public. A U.S. District Court judge granted their request by ordering the State Department to reverse steps it had taken to pave the way for the dissemination of these digital files. The State Department, after conducting a 5-year-long review, and as part of a settlement it entered into with the Defense Distributed Company in a different federal court involving the potential exporting of these files, had recently concluded their dissemination would not provide military advantage to foreign adversaries and thus are not subject to export regulations. So the U.S. Department of State did a 5-year analysis of these digital files and determined that disseminating and sharing of them would not adversely affect the national security interests of the United States. That's a big win for Defense Distributed. Well, it's strange that the State Department had even entertained the idea that national security interests could be harmed by the dissemination of digital blueprints for non-military small arms. Stranger still that the state attorneys general and a federal judge believe they have the legal authority to nix this settlement entered into in a different court involving an issue, arms control, that the Constitution clearly reserves to the federal government, and to try to override the decision made by the executive branch on a matter the law clearly states is not even subject to judicial review. But nevertheless, we now have a judicial order prohibiting this settlement from occurring. Although the courts have held the Arms Export Control Act, from which these arms control regulations originate, was enacted to permit the executive branch to control the export and import of certain items in order to further world peace and the security and foreign policy of the United States, even though that's the express statutory requirement and admonition behind the arms control statute. We now have state attorneys general in a U.S. district court interfering in the president's, the executive branch's, foreign policy and national security interests and jurisdiction, interfering in that in ordering the executive branch of the U.S. government to rescind actions it has taken under its express statutory and constitutional authority. Well, this is judicial activism, and this is wrong. The lawsuit filed by Pennsylvania Attorney General Josh Shapiro in the United States District Court for the Eastern District of Pennsylvania is just as wrong. Not only does it contain several misleading statements of fact, such as this one, imminently members and others will be able to download an actual working gun. In this one, they are selling actual working guns, and the defendants deliver your gun to you directly through your internet connection. No ID, no background check, no waiting period. It's as if Cody Wilson is on one side of your computer holding a gun, and he reaches through the computer and hands it to you. Furthermore, and much to the surprise and chagrin of gun control advocates, Pennsylvanians who are not legally disqualified from possessing firearms have the right to make their own non-military small-arm firearms for personal use, whether from a blueprint handed down by a grandfather, found in a local library, or now via computer. We've had this right since before the founding of our country, and contrary to what Shapiro would have us believe, there is no ID, background check, or waiting period required. What Defense Distributed would like to do is perfectly legal in Pennsylvania. And that's why, although Attorney General Shapiro alleges in his lawsuit that Defense Distributed is violating Pennsylvania criminal law, he has not filed criminal charges because they would be dismissed. Instead, he has filed action under some sort of vague common law public nuisance claim and the Unfair Trade Practices and Consumer Protection Law. Well, ask the Attorney General how many complaints he has received from unhappy consumers of 3D downloadable firearms. I'll bet the answer is none. The lawsuits brought by the state attorneys general are of dubious legal merit. Regrettably, it appears these state officials will use the law in a way it was not intended in order to try to achieve their policy goals of gun control. But state attorneys general don't make law. They enforce the law. Yet it's perfectly legal for Defense Distributed to do what it's doing. The Attorney General of Washington bluntly acknowledged he will make it as difficult as humanly possible to access this information. The state attorneys general would sue individuals and corporations for engaging in lawful activities as a blatant misuse of the law. Well, that's your Scaringi Law Lunch Minute this week. I want to thank you for listening. We've been talking a lot about firearms law over the past several episodes, and that's in part because I was teaching a gun law seminar in Pittsburgh on Friday to other attorneys. And in the upcoming episodes, we're going to move on and talk about some other interests, other legal interests that may be of interest to you. Well, that's all the time we have today. Thanks for listening, and enjoy your lunch.